Yes, good afternoon to everybody. That welcome to the today class of the law of insurance, and we are dealing about the doctrine of feeding back, the grant of feeding back by Estoppel. That was the thing. And read what I cited on the screen. Anyone? Yes, unmute and read what I cited on the screen.
Think in the morning, act in the noon, eat in the
Yes.
evening, sleep in the night. Good afternoon, Professor Dr.
Yes.
Muhammad Saib Hussain.
Yes, that is the think in the morning, act in the noon, eat in the evening, sleep in the night. Of course, it is, shows the timely activity of the person because time is a very important factor. And that we are dealing the still the doctrine of feeding the grand by Estoppel as we read it, and we are at that place, the middle of it, we stopped. So here, let us again deal that B. Narayana Swami Naraswamy Raju versus Krishnamurti Mudaliar, that is the AR 1988 Madras, where the vendee had purchased the property and with full knowledge of right of their vendor, that there was no evidence to show that there had been any fraudulent or erroneous representation. Oh, ho, 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 you did not mute it, so I will mute. Right. So, here, there is no evidence that the vendor has made the fraudulent erroneous representation that the vendee had acted on the it. Madras High Court held that doctrine of feeding the grand by Estoppel was not attracted. So the attracted at that instance only when there is a clear, what I say, erroneous representation, a fraudulent representation by the vendor to the vendee, and the vendee acted upon it. At that instance, Section 43 would be applicable. So illustration that we have seen, A obtained a property by way of exchange from B. At the time of the exchange, B only had a half of the share, but he professed to transfer the whole. When B subsequently purchased the remaining half, A was held entitled to it. Yes, in the beginning, there is only half is there, but A has told that the completely the share. So after that, he acquired the half of the share later part. At that instance, B can tap the section 43. So that we did in the last class. So the same thing, a mortgage half share in the family property to be in which he had only one third share. At that instance also, he made erroneously and fraudulently would transfer and a process to transfer the property to the vendee or the transferee, and the transferee acted upon that, but later on the transferor acquired that property. At that instance, what he said in the beginning, it will be doctrine of Estoppel will be work over there. Then he did not say that, or he could not say that I did not say it because he said already. So transfer for consideration that we are dealing now. Transfer for consideration means the transfer under the section must be for consideration. This section does not apply to gratuitous transfer. If a transfer is without money, gratuitously, or the transfer of in the form of the gift, the section 43 will not be applicable. It applies only to the transfer for value. It may be applied to mortgages, sales, exchange, lease, because they are supported with the consideration, but not to charge or the gift. In the charge also there is no consideration. In the gift also there is no consideration. At that instance, section 43 will not be applicable over there. So subsequent acquisition of the interest. Let us see what is the subsequent acquisition of the interest. Transfer must acquire interest in the property which he had professed, agreed to transfer without any interest or authority. In the absence of such acquisition, this section cannot be invoked. Such subsequent acquisition of the interest or authority shall pass to the transferee. Suppose if there is no subsequent acquisition, at the time the section 43 will not be applicable over there. Then directly we can file a case in the form of a deceit or cheat or fraud. Is it clear? Unmute and give me the reply.
Yes, sir.
Very good, very good. So now we will see that what are the requisite would be there when you say the subsequent acquisition of the interest is concerned. Yes, the requisite is there that the A at the transfer is option. So always it is a transfer is option would be there for doctrine of feeding grant by estoppel would be asked or would be tried. So transfer is having the options the thing. And number two, at any time during which the contract transfers substitute. So another is point is that the contract of transfer should subsist. Means the vendee could not revoke the transfer, or transferee could not revoke the transfer. Still, it is in existence. Means it's live. If the two conditions are there, then the transferee is having right to apply the section 43. That is the whole idea behind it. So now we will go to the next point. In the case of the Brahmavarta Santan Dharma Mahamandal Kanpur versus Prem Kumar, there is AR 1985 Supreme Court 1102. Three daughters inherited their father's property as a limited estate and divided the property into three shares, each being the exclusive position of her respective shares. One of the daughters, A, sold her share in position to B. So one of the daughter what they did, he sold her share in position to B. So which is in position to B means does it mean the in position to B means where the position is already will be there with the A, that position will be given to the B. So because already that share is there. Subsequently, other sister died and A remained the survivor at the last limited owner and got exclusive possession of the whole estate. So one after another, the another daughter also died. Then became only one single heir would be the possession of the whole estate. The court held that B was entitled to the property under Section 43. So at that instance, Section 43 will be applied over there because at the time of the transaction there is no how would I say ownership would be there, but ownership is later acquired. At that instance, option is there of the transferee to use such an option, that is a section 43. If the transferee option B, the entire state could be taken by B from A, provided there would be a consideration for the rest of the shares. For any other thing, as I told you though, in this transaction, share consideration is very much important. If the transfer without consideration, where we cannot get the advantage of the section 43, so we cannot use it, or there cannot be applicable over there. So the property subsequently acquired, whatever the property the transferor acquired subsequently, does not pass automatically to the transferee. It will not pass automatically transferee. Transferee should have to emphasize. That means satisfying the claim of the transferee, two conditions must be satisfied which cited above. That is what number one, at the transferee option there, his intention would be there to take the such property. Number two, any time during which the contract of transfer subsists, means contract should not be revoked over there. So the contract is, should be subsist between the transferor and transferee. Then only we can tap the section 43. The property subsequently acquired with the transfer does not pass automatically, as I said, to the transferee. For satisfying the claim, transferee two conditions will be satisfied, which are cited above, and we read it. At the transferee's option. So what is there in the transferee's option? Yes. After the transferor acquires the interest in the property professed to be transferred, the transferee must exercise his option because the property will not become a transfer him automatically unless until the transferee will file a case and ask for the revival and ask for the transfer of that property which later part the transferor acquired, then only he can claim it. Suppose automatically it will not pass to the transferee. So there is no particular form of exercising option. It may be gathered from the acts and conduct of the transferee. It may be exercised at any time during which the contract of transfer subsists. So when the contract of the transfer subsists only, these things can be possible where we can tap the section 43. If not, we cannot tap. So at any time during which the contract of transfer subsists, so now we'll see at any time during which the contract of transfer subsists. So the transferee can claim the property only during the subsistence of the contract of transfer. So when there is a contract only, at that instant only, the contract will be fulfilled. That is the reason. A contract exists till it is not rescinded or extinguished in some other manner. Suppose if the contract is not rescinded or contract is not extinguished, at the time the subsistence would be there still. where the transferee rescinds the contract. Suppose the transferee took the option to rescind the contract on on a finding that transferor had not interest in the property and brings the action for damages, this section will not be available. So now, where this section will not be available, where the transferee rescinds the contract. Of course, there is no contract between the transferor and transferee. At that instance, he cannot make this contract is a valid contract because he rescinded earlier before he acquiring the property. Yes, in a case the mother of a minor son sold their joint property. Okay. The minor son, on attaining the majority, challenged the alienation made by his mother in respect of his share and obtained a degree. But he died before he could obtain the degree, means possession. The mother inherited the property of her son on his death. Okay. It was held that due to the decree of the in favor of the son, the claim of the vendee in respect of the son's share was not valid, because at the time it is not clearly mentioned there is a share for the son. So it is not valid and he cannot get the advantage of the section 43. So he could claim only the mother's share because the mother's subsequent acquisition will not feed the title of the vendee. So here the mother shares will not feed the title of the vendee. That's why this section will not be applicable over here. So the transfer in good faith. What is the transfer in good faith? Are you following me?
Yes,
This
sir.
is the this is the repetition that I am making because already we dealt it. But again, that I am throwing light so that you could have to remember the well. So transferee in good faith. So what is meant by good faith transferee? That means transferee should have to take a reasonable care to know that a transferor is the real owner or the property, what he said, what is professed is there or not. Suppose if you say I have to have the 3 acres, so he is only the position of the 1 acre, other 2 acres, the two brothers are in position. But he is taking care of the everything, brother's property. At that instance, he said that I would like to sell the 3 acres to you. At the time of the transfer, there is no 3 acres, it is only 1 acre. At that instance, he later on he acquired the property. How? One of the brother died. Okay. Then another brother also died. Then the entire property comes to the A, that is the 3 acres. At that instance, transferee is having the option to exercise it. Yes, now you transfer all the 3 acres because the contract is still subsisting and the contract is not rescinded. If it is rescinded, you will not get anything. Okay, what is the good faith here? A reasonable care should have to be taken to know that whether he is having the property or not. If he is having the property in his possession, whether it belongs to him or not. So these are the things we should have to see in the transferee in good faith. Transferee cannot enforce his claim against a person who has taken a subsequent transfer from the transferor in good faith. Yes. Here, for consideration and without notice of the option vested in the transferee. This means that where the second transferee in good faith. So yesterday that we have taken one case law because A would like to sell the some property to B, not the entire property one by two, because we did in the same way. Suppose not the entire property, only half was there at the time, but later half he acquired over there. Then total one. So one can acquire it because the discretion is given to the transferee to exercise such a thing. But suppose the B could not know whether the A is a bona fide owner or not. He could not take the care to see whether he is a bona fide owner or not. So this means that where the second transfer in good faith has paid the consideration and without the notice of the option takes the property before the option is exercised and shall not be affected when the first transfer is claimed under this section. Let us see the one example so that we could understand what exactly the thing, because there are two transferees. Number one, the prior transferee. Number two, the later transferee. If the later transferee purchase thinking that there is no contract between the some P and Q, because he knows it. Like the P as a transferor, Q is the transferee. At that instance, yes, he can be bona fidely believed that he could not have the knowledge of it, but later I have the knowledge of it, he can take the P. For example, where A on partition receives the property X. So he received the property X on the partition, and the other property Y goes to his father. So his father, it goes to over there. So because the property goes in the father because of the joint property, and A representing that he owned both the properties X and Y, because Y is in the custody of B and X is in the custody of A. So and X and Y sold to them to C. He professed that he is going to sell that the property which is already there. So at that instance, yes. After that, when B dies, A inherited both the properties of X and Y. Suppose the B dies because the Y property in the custody of the B. If the B dies, then the property X and Y comes to the inherited by A. But before C could exercise his option to compel A to transfer property to him, Y to him, A secretly sold the property to D. So here, A secretly sold the property to D, but D doesn't have the knowledge that there is a contract between A and B. So D purchased the property in good faith for consideration without having any notice of the option of the C, of the option of the C. So D is entitled to get the property Y as against the claim of C. Yes, he can be entitled because he's bona fidely believed in good faith he has taken over there, and hence the second transfer is a valid transferee, and the property goes to him only. So that is the what I want to say. So what is the invalid transfers? The how the invalid transfers are there. For getting the production of this section, it is necessary that the transfer must be a valid. So a valid transaction only that is to be undertaken. So valid transfers. This section is not applicable where the transfer is forbidden by law or against a public policy, and to those transferors who are void of an issue. So those who transfer wide area ratio, it cannot be applied over there, and it cannot be there for the transfer must be valid transfer. Means transfer also should be a valid transfer. That is also one. Otherwise, it becomes an invalid transfer. So conflict between the 43 and 6A. Yes, can you tell me what is 6A? Anyone? Because we read it. All the properties can be transferred except section
Excellent.
A to section I, where in the middle there is a double D also comes. So now conflict between the section 43 and section 6A special section is 6A means special section is according to section 6A the chance of are an heir apparent. The chance of heir apparent as success, special successionist we can say. So special succession is to get the property in future is non-transferable right, and its transfer is void ab initio. So whereas section 43 validates the transfer made without when the transferor subsequently acquires the property, he knows the question arises if the property professed to be transferred happens to be special succession is and subsequent to the transfer of the transfer acquires subsequent to the transferor requires it. Yes, whether the transferee will be entitled to seek a production of this section for claiming the subsequent acquisition of the transferor. Therefore, on a plain reading, there appears to be conflict between those two sections. Here, let us see what is the conflict between the two sections, what section 43 says and what section 6A says. So, in case of the Jumma Masjid versus Kudimaniandra Devaya, Kudimaniandra Devaya, that is the AR 1962 and Supreme Court 487. And there the citation goes, that is the AR 1962, SC 847. An heir apparent, I repeat, an heir apparent sold his would-be share in a joint property to Masjid for rupees 300. Subsequently, when the of course, when the transferor becomes entitled to the property, Masjid invoked the section 43 to compel him to pass the property to Masjid. So it is a Masjid property, you are not supposed to take it. Moreover, it is taking is illegal, rather we can say. So the transferor contended that the interest transferred was a space successionist. So when it is a space successionist, means apparent thing that he is going to get it. And wide ab initio under section 6A of a TP Act. And there, section 43 could not be applied to make a transfer valid, which was wide ab initio. So the Supreme Court held that Masjid is entitled to the protection of the section 43, and the advisor and the transferor was made to pass on the title of the Masjid. The SC observed that the Supreme Court observed that the section 6A was rule of substantial law, and the rule of substantial law where the section 43 was based on the Estoppel, which is fraudulent of event. So illustration, let us see what it clearly gives. A representing himself to the owner of certain property, X. So X is the property name, A is the owner of the property, well and good. And may X, a certain property X, made a gift of it to by a registered document. So by a registered document, what he did it, the property K is given to the B. So on the date of the gift, it was found that the property actually belonged to C. So when he checked it, it is actually belonged to C, but not to B. A subsequently purchased the property from C and B filed a suit to get the possession of either property. So yes, possession of the property again. And at that instance, that is A, the court held that suit by B is liable to be dismissed because the transfer being a gift, when it is a gift, there is no consideration, hence the transaction is wide, was without consideration. So that is an example where there is form of a gift has come, it doesn't attract the provision. So it will not attract the provision in various other factors like section 6A, it is a space successionist. So now comparison of the section 41 and 43 that we see it. In a safe sale by ostensible owner under section 41, the transferee does not depend upon the representation of the transferor, but in good faith takes reasonable care to inquire about the authority of the transferor, the transfer of the property, whereas in feeding the grant by the election under section 43 of the transfer of property, the fraudulent and erroneous statement of the transfer to be true. That is the comparison of the 41 and 43. The second is ostensible owner is the person who is not the real owner, but he holds himself out as the owner and the transferee takes the property from him. Whereas under section 43, the transferee gets the property which does not belong to the transferor and he can claim that property from the transferor only when that property by some chance in future comes into the transferor's share. Yes, the transfer share will come at that instance only. One can tap it, this doctrine of feeding back by Estoppel. The Estoppels works against the real owner under section 41, whereas it works against the transfer under section 43. So in the 41, it deals about the works against the real owners. So real owners, they will work, but here dummy owners are, we can say, in other words, yeah, we can say the dummy owner because he is not the owner. And he benami, rather we can say, where it works against the transferred against that section 43. So next point is the transferee under section 41 takes off from an ostensible owner, whereas under section 43, the transferee take from a real owner. Yes, because he takes a real owner because the property acquired later and he also became a owner of that property. Next, the fifth distinction or comparison. Under section 41, the transferee must inquire about the authority of the transferor, whereas under section 43, he has to pay the consideration only. So that is the fifth. Now the sixth is under section 41, the transferee must not have notice of the real owner's title, whereas whereas the one under section 43 should have to no choice of option in favor of the first transferee. Yeah, that is another distinction they made it out there regarding the 41 and 43 is concerned. I repeat, under 41, the transferee must not have notice of the real owner's title. He doesn't have the real ownership title over there. But whereas the one under the section 43 should have no interest of operation in favor of the first in transferee. So they will not give you such a preference over there. So that is the distinction that we will find. And the next distinction is that is eighth, no, seventh. Both the transferees must take the transfer in good faith. Under section 41, transferee must be healthy, believe that the ostensible owner who had an opportunity to try to the transfer, whereas under the section 43, the transferee must believe that the transferor has transferred the property to him for the first time. So that is the also one of the distinction we will find it in section 41 and 43. Yes, now we will see the what is the distinction between the section 6A, that is a special section is, and section 43 of the Transfer Property Act. So if you see the section 6 small a deals with the transfer of special successions, special successionist. So which means a chance of succession. Succession 43 speaks of the transfer of property which one does which one which on the date of the transfer does not belong to the transferor, but he fraudulently or extra or erroneously, both the word they could use it, fraudulently or erroneously represents that he is authorized to transfer such property. Yes. The second distinction is section 6A declares that transfer of the classes of interest described in the it is wide. So if you classes the interest in described, then it become wide. Or declare that class of interest is its wide. Yes, it become wide when if the classes would come over there. If even if after the transfer, I repeat, even if after the transferor acquires the interest in the property transferred, interest will go to the transferee or he will not get any interest in the property. So now apparent by seemingly is different, later on he acquired is different. So section 43 relates to the representation of the transferor with regard to the title in the property which on the date of the transfer he did not possess it. But later on he got the position. The transferor becomes valid. The transfer becomes valid. Section 43 also provides that when after transfer, the transferor acquires the in the property, transfer to the benefit to the subsequent acquisition goes to the transferee at his option, provided the contract for transfer in respect of said property subsists. That means a contract should be subsist over there. That means the transferee cannot revoke the contract. So when he makes a presumption or he does a particular thing without giving the notice of legal separation or the divorce or any other thing, at that instant transferee could not could not do so if there is no subsistence of the contract between the transferor and transfer. The next distinction, the transferor represents himself as the only legal heir entitled to succeed the property, the transferor. It does not amount to fraudulent transfer, section 43, where the transfer represents himself as the owner of the property. It amounts to fundamental transfer. So that is the thing. Then again, the section 6A enacts a rule of substantial law, but whereas the section 43 enacts it's the rule of estoppel. The approved under the section 115, the list of the approval should be done by the yes, transferor. Yeah, of course, the transferor and transferee, both the things are here. So, section 115 says Estoppel provided also the evidence will give it. Rule of Estoppel as provided in the section 115 of the Evidence Act also there. So, 43 also Estoppel is there and 115 also Estoppel is there, but 6A is different, which is substantial law, but these are all procedure laws. Section 6A applies only where the transfer is intended to special succession is. Yes, to the knowledge of the both the parties and not where the transfer proposed to be one of the present in the property. And the transfer is not aware of the defect of the title. Of course, the transferee should not have the defect of the title, should aware of the title. Suppose if he knows that defective title would be there, then Section 43 will not be applicable. Section 43 will apply and operate on any interest which the transferor may subsequently obtain the property. Yes. Next is, it is the hope in Section 6A, and I repeat, it is a hope in Section 6A, but in Section 43, it is a fact. So it is a hope, it is a fact. So that is the hope cannot be surveyed, but fact can be moved. So next seventh is the person is special section is not put in position. Section 43 in majority cases position of the property of the real owner are transferred. So that is the distinction that we will find in the section 6A and section 43. Yes, following are the ingredients of the section 115. What did say Indian Evidence Act? Yes, what is they say 115? Number one, the following are ingredients of section 115 that is divided as follows. Number one, there must be some representation. Yes, the representation leads to the erroneously or leads to the fraudulently. Of course, it will come one option like that. There must be some representation. Okay, the representation must be made with that intention to be acted upon. Yes, the representation made. The intention is there to perform such an act. Number three, the representation must have been acted upon. So, whatever the limitation they put it over there, whatever the thing they put it over there, that will be tucha tappakunta, that's followed. So, the representation must have been acted upon by the transferee. Number four, such action should have been detrimental to the interest of the person whom the representation has been made. So, it is detrimental to the future of a person and who is the employer. Such an action should have been determinal to the interest of the person whom the representation has been made. So these are the certain highlights between the 6A and 43 and 41 and 43 that I made it clear. So if you happen to see the syllabus, you will find only the one thing. That is the doctrine of feeding the grant by Estoppel. That is only the thing would be there, but it is having the many other factors also. So now the next case law that what we are next topic that we are going to do is the doctrine of lispendence that we will read it tomorrow. Sir, tomorrow is Sunday. Okay, Sunday is a holiday. So take the rest and try to help your father, mother, and spend a lot of time with them. And if you have children, you spend a lot of time with them also because love and affection they will increase it in geometrically, and it will be a must for a good bond between the child and father. Yes, any other thing that you would like to ask? Unmute and give me the answer. Yes.
No, sir. Thank you, sir.
So this is the a bit one form in another form it is a repetition, but we dealt in a good way, good manner. So generally, if a 15 marks question comes, doctrine of feeding the grant by Estoppel, we should be in a position to write, including the case law which I mentioned. So yeah, of course, in any book also you will get it, or in the website, in the much information also you will get it through the net also. Just you type the doctrine of feedback by Estoppel, then you will know it. Either the YouTube lessons also there. So with this, I would like to stop my things. Then before I want to say bye, thank you. Yes, thank you. Slide that I put it over there, and we'll see you on Monday and the same
Thank you, sir.
3:15. And once it is over, that I will load it in the YouTube and inform the other people also. Listen to the YouTube. Those who are absentees. So that is.